Hello, everyone, and welcome to today's webinar. My name is Caleb Tingstad. I am a lawyer here at Beresford. My practice primarily includes transactional work and general business representation, and I do a fair amount of litigation as well, and that litigation is primarily confined to what we refer to as business divorce cases. And a frequent aspect of business divorce cases involves what we refer to as minority shareholder oppression. So you are a shareholder in a corporation, and the majority is taking advantage of you in one way or another. And so we are going to talk about minority shareholder oppression today, specifically as it pertains to Washington. These types of disputes are very jurisdictional, and so it matters that we're in the state of Washington because Washington has its own rules. So today we are going to cover just exactly what is shareholder oppression and what's the kind of conduct that courts are looking for when they are deciding whether shareholder oppression is occurring. We'll take a look at the tests that courts utilize from a legal perspective to see whether the facts match up to a finding of shareholder oppression, and then we'll talk about some of the considerations that both practitioners and shareholders, either from a majority or a minority perspective, ought to be aware of based on the things that we're talking about here today. So first and foremost, what is shareholder oppression? So it is a cause of action, and it's actually a cause of action that arises from a Washington statute. And it's important to note that we're talking about shareholders, so this is going to be limited to Washington corporations. And that's a key distinction. Minority shareholder oppression likely does not apply to minority members in an LLC because Washington's LLC Act does not provide the same statutory right to minority LLC members as it does to shareholders. And so while it is a cause of action, it brings about a remedy. And the remedy in this case is almost always dissolution. And what comes with dissolution is usually the appointment of a receiver or some other court-appointed representative to dissolve the company, wind up its affairs, and liquidate its assets. And so now that we know that it's a cause of action, the next important piece here is determining, well, what constitutes oppression? And what courts have talked about is it's basically the idea that you have a majority and a minority, and majority and minority does not always necessarily mean that the percentages of the shares are 60 to 40 or in an actual majority minority situation. But courts are more so looking to see who actually has control. So there may be instances where you could have a 50-50 corporation in terms of how the stock is split, but if one of the shareholders is the shareholder that actually exercises control, then the court will basically impose the title of a majority shareholder on them. And the idea here is that courts are trying to impose obligations on majority shareholders to protect the interests of minorities. And so one of the things that we frequently see in cases involving shareholder oppression is, and I'm quoting from a case here, is the siphoning off of profits by excessive salaries or bonus payments. So when you're looking at a corporation, normally the officers of the corporation are going to receive certain salaries or bonuses, either discretionary or subject to an actual schedule based off of performance. And most frequently in shareholder oppression cases, what you have is you have the president, who is also the majority shareholder, the one who has the control, and instead of he wants to make sure that there is no money left over for dividends to be made to the minority shareholder. So what the majority shareholder and the president will do is he will pay himself a very, very, very high salary, just enough so that there are no profits, and which means there are no dividends to be paid to the minority shareholder. And so, to protect against shareholder oppression, and to figure out whether there is in fact shareholder oppression, courts in Washington use two tests. You have the reasonable expectations test, and what I'll refer to here is the violation of fair play test. These are both tests that are recognized in the state of Washington, but they're different depending on who the minority shareholder is. So the reasonable expectations test will apply to only founders of a corporation, and it's a test that is unique, that is looking at the specific circumstances of the founders and the corporation itself. So what was the minority shareholder told when he first, put in his money or started rendering services on behalf of the corporation? Maybe not even necessarily what was the minority shareholder told, but what did they expect? And so it really is the reasonable expectations test is really a personal analysis of the situation of the parties. Whereas the violation of fair play test, which is available to all other minority shareholders that are not founders of the corporation, is more so a standard that looks at what the average shareholder would reasonably expect. So the reasonable expectations test is looking specifically at the circumstances as they apply to the shareholders at issue, whereas the violation of fair play test more so looks at the average, what would the average shareholder expect in those types of situations. All with the idea being that the court is looking at the conduct of the majority to see, hey, did the majority's conduct violate in the reasonable expectations test what the shareholder, when the shareholder first contributed its money or its services at the founding of the corporation, what the minority shareholder would expect, or what the minority shareholder was told. So, for example, if the minority shareholder is told, hey, you can expect that, we won't ever take salaries that will leave less than X amount of dollars for distributions. Well, if that's what the minority shareholder is told, even if it's not in writing, and the majority ends up violating that and pays itself a disproportionate salary such that there are no distributions to be paid, then the court would say, okay, that's a violation of the minority's reasonable expectations. So with all these things in mind, perhaps the most important thing is, there is what happens in the event that something like this, that oppression does occur. And really, it's such a case-by-case basis that there is no best approach for going about and litigating or negotiating your way out of a situation where either you are being oppressed or the minority is accusing the majority of oppression. Perhaps, from my perspective, the best thing to do is for the parties to put themselves in a position where this type of thing never happens in the first place. This is why, with my transactional perspective, I'm always trying to get clients to put down what their agreement is on paper, and so that everybody is clear from the outset, hey, this is what your rights and these are what your responsibilities are. And also, depending on from a practitioner's perspective, depending on who you're representing, you're going to want to do certain things to protect your client's interests. And when I represent minority shareholders, I am always trying to be conscious of the fact that I don't want to leave my clients out to dry. I don't want to put them in a position where they can be oppressed. Which is why we're always trying to think about how do we best protect the voting rights, and what are things that we can build in to the agreements between the parties to make sure that the minority can't necessarily get taken advantage of. And that is really the extent of today's discussion about minority shareholder oppression in Washington. Like I said before, from a litigation perspective, these are such a case-by-case basis, and there really is no one-size-fits-all approach or analysis to anyone's situation. And also, from a thinking ahead perspective, similarly, it is very much so a case-by-case basis, and how you go about protecting your client's interests is a difficult thing that is you can only approach once you know what your client's interests are and what their goals are for the representation and also for the venture that they're getting themselves into. So if you have any questions, my contact information is on the screen. You can feel free to reach out to me. And I thank you so much for taking the time to listen in.
And that's about it for today. I need to get going, and but I'm always happy to answer questions. I'm always happy to discuss your case with you. We do, we do consultations here, and if you want to give a call and set up an appointment, I'm certainly happy to talk with you more about parenting plans, more about the solutions, more about strategies for trying to deal with various issues that happen in families, and trying to get the parenting plan that you as a parent believe is in the best of your children. Again, I'm Susan O'Toole, and here's my email address and the phone number of our law firm, and they can put you through to me, and I'm always happy to talk with you. Have a great day and take care. Bye-bye.